If you would, please give your name, and if you're representing somebody other than yourself, who that might be.
Good afternoon. Thank you so much.
And get as close to the microphone as you can.
Good afternoon. Thank you so much for this opportunity to speak to you. I come all the way from Orange County, California. I wanted to tell you about my harrowing story of my son's medical abuse, extreme bias against a protective parent, retaliation for exposing the truth, and sex utilized as a bargaining tool for custody. I am a teacher and a school principal in charge of an entire school of children by the state of California, which grants me teaching credentials. I'm also a mandated reporter, and I've also had to report abuse or suspected abuse to CPS. My son Jacob was a happy, healthy, and thriving young man, a child at the time, for 12 years that I raised him. Unfortunately, when we went through family court, he was appointed a minors counsel, which is similar to guidem ad litem. Minors counsel Diane Vargas provided false testimony in court as a retaliatory effort against me since I filed 2 bar complaints regarding her professional misconduct. The judge also decided to retaliate against me as well. And the judge, Donald Gaffney, legally kidnapped my son from me since I exposed the truth regarding minors counsel's ICE in court through documentation. Minors counsel falsely testified in court that my son was in danger and that I was an unfit parent. However, the 730 evaluation that was court ordered stated no such thing. I was placed on supervised visits for 4 hours a week despite raising my son for 12 years and also having 2 grown adult daughters and being an educator and a mandated reporter. As a school principal, I have 2 master's degrees in education. But yet I was being supervised by someone without a college degree. I was so perplexed by this train of events. Due to the cost of supervision, I had to sell my home and to pay for my attorney's fees and all the reunification therapy that I was subjected to. The court refused to provide appropriate alimony despite the enormous disparity in incomes. As a teacher, I made a meager salary, which I was very grateful and blessed with. However, my ex-husband made over $300,000, which was over 3 times the amount that I made. But I was only given $468 a month to survive on. My son Jacob was medically abused by my ex-husband, but Judge Donald Gaffney at the ex-parte hearing said there was no such abuse, despite medical documentation. I also filed 2 CPS reports informing them of my son's medical abuse, and it was disregarded.
Excuse me, ma'am.
Yes,
when
sir.
you say medical abuse, can you further define that for me?
Sure. My son, through the medical records, where his stepfather, which was my ex-husband, it's not even his biological father, took him to the doctor and performed various medical procedures, yes, that were not, that he had already had at that point. And the doctor's office didn't think to question this previously or to obtain previous medical records from Chalk Hospital.
Okay.
My son Jacob is now suffering with lifelong medical complications, and he will for the rest of his life. In 2021, I had asked my ex-husband if I can see my son because I knew the court would never grant me custody of my son, despite me being in charge of the health and welfare of an entire school of children as a teacher and a school principal. My ex-husband provided an offer that I exchanged sexual favors in exchange for seeing my son. I was sexually raped for 6 months, but I had access to my son. And as a mom, I would do anything for my son. Apologize.
Take your time.
After the 6 months, I could no longer endure the abuse. We went back to court, and the judge said that I had violated a court order by seeing my son, and I was the one who was punished. My ex-husband, David Velema, was not punished for raping me and not allowing me to see my son in the process. There were 2 judges, Donald Gaffney, as well as Judge Thomas Lowe at the Orange County Family Courts in California that presided over my case. And both of them denied me alimony, custody, and also terminated my visitation rights. Even though the state of California allows me to be in charge of an entire school of children as a principal, as a teacher, for the health and welfare of these children, but yet I don't have access to my son, that's really disturbing to me as a parent and as an educator. I once again became a danger to my son, and the court and minors council refused to let me see my son. And again, I was placed on supervised visits. This reunification therapist, Jessica Sinclair, was appointed by the court, and she did not take insurance since she had previously been convicted of insurance fraud. And I was forced to pay cash or Venmo, which is from my checking account, for these reunification therapy sessions. Again, she provided false testimony in court to increase her profit margins. I want to express to you how far I've done, as many parents have spoken today. I filed, besides the 2 bar complaints that I filed against minors counsel that were dismissed by the bar, I filed 2 judicial complaints against the 2 judges. That was dismissed. I also wrote to the Board of Behavioral Sciences that is in charge of Jessica Sinclair as a therapist, and have not heard back since, and I know many other parents have done so as well. She is no longer teaching by choice, or I'm sorry, not teaching, sorry. She is no longer a part of the Orange County Family Courts in California by choice. She recused herself because of all the articles that have come out regarding the corruption that she perpetrated against the clients that were court appointed. She is, however, practicing in another state. I've also reached out to the FBI to inform them regarding the legal kidnapping of my son. It's been 6 years that I have not been able to see my son, except when I was raped, and that I was allowed to spend time with my son. For all I know, my file's sitting on an FBI office just collecting dust. I've called and spoken to 4 FBI agents, and they informed me that they can't provide any status on my case. To me, as an educator and responding to parent concerns, student concern, and staff concerns, I provide due diligence to ensure that I problem solve and I work with the people that I'm put in charge of. If the highest levels of government, if I can't depend on them, who can I depend on? Is it possible to make our judges accountable for their actions and not have immunity for abusing our children? Thank you for your time. I appreciate you.
Thank you, ma'am. Members, any questions?
Mr. Chair, if I can address an answer to Senator Hatali. She had asked a previous parent regarding finances. Just in my case, if I can speak to that, the court asked for a financial documentation. So all our paycheck stubs, bank statements. So when they look to see that one of the parents has a substantial amount of assets, they will drag it on for as long as they can. And that's how it's deduced as to the colluding that takes place regarding the abuse that our children are enduring.
And I presume that California law is similar to Arizona law. You don't have to agree to the so-called therapeutic intervention with that broad basket of psychological word salad. You don't have the option to agree to participate or decline. Is that correct?
No, it's court mandated,
Okay.
Mr. Chair.
Regardless of anybody's ability to pay.
Correct, yes. I wasn't able to pay, and therefore I had to stop at one point the supervised visits, and then I collected some more money as family friends for funds so I can continue to see my son.
All right. So let me say it another way. They don't care.
Yes, Mr. Chair.
Did the court question you, and this does have relevance here in Arizona, did the court question you on what other family members, what assets they might have? Did you have to disclose that to them, or was there discovery about that?
Not to my knowledge, Mr. Chair. It was just what my ex-husband and I had, our paycheck stub, the home we owned. Okay.
It just seems somewhat curious to me that they would force that on the earnings of a lower income parent as opposed to one who is perhaps more capable of covering the cost. And not, was there any opportunity to have a a proportional assignment of cost, or did that not even enter the conversation?
Well, that's where it's decided upon, depending on the DISO master, how much you should get for whether it's child support or alimony. But because my attorney at the time was colluding with minors counsel, it was actually a conflict of interest. She had been his mentor during law school. So because of that, there's a current situation around that situation.
Okay,
Regarding the law firm, but yes, so go ahead.
Who, your attorney, was the mentor to who in law school?
So minors counsel, which was my son's attorney appointed by the court,
Okay,
was the law professor or mentor for my attorney.
and the court saw no conflict of interest there? That's stunning.
No.
Okay. Representative Cashel.
Yeah, so thank
And
you,
I-
Mr. Chair.
I'm so sorry to interrupt. I wanted to also say there's an article, Sex for Custody in Orange County, California, and Representative Keschel, I did email that article to you.
Okay, would you see to it that we get that? for the
Yes,
record? Okay.
I will. So thank you so much for coming. I'm sorry for everything you've been through. But from what I just gathered from something you said that's a little shocking to me is the court order on your supervised visits was based on whether you could pay for the therapy or not. Did you say that when you were unable to pay, they took away any visitation from you, or did I misunderstand?
So we had gone to court to inform the judge that I could not no longer pay for supervised visits. So at that point, the judge, just said, well, if you can't pay, you can't see your son. Then when I took some time, collected some money, and like I said, family, friends, was able to get some substantial funding, then I wanted to still see my son and didn't want to get raped again. And so I wanted to be able to see my son. So then I went back to court, and the second judge, Thomas Lowe, that's who my case was transferred to, he denied me visitation and custody of my son, despite me being in charge as an educator and a school principal of an entire school of children by the state of California.
Mr. Chair.
Representative Fink.
Thank you. Maggie, thank you for coming all the way from California. I have some questions on the reunification therapy. Why was that court ordered? Was there efforts to get, again, that reunification effort so your son would go to the stepfather, or why was that ordered?
So after going back to court, after being sexually raped for 6 months, the court said that I was the one at fault in violating court orders. Minors counsel again lied in court. It was the same one, Diane Vargas.
Okay.
She informed the court and lied to the court and said that the child didn't want to go with me, even though he had just spent 6 months in my home. And so that's when the judge, again, honored her request and the false testimony she provided again,
Okay.
and sent me to reunification again.
Again, and therefore, after that, with that therapy, finding out that she had insurance fraud and all of that, was that taken into consideration at all? Okay,
No, Representative Fink, no.
okay, thank you.
Members, any other questions? All right, ma'am, thank you.
Thank you for